Okay. Thank you for joining. I'm Abby Solomon. I am the program manager for Cultivator. We are an innovation center and business support hub startup in Randolph, Vermont, serving the Randolph region. We are working towards having a location downtown that will be a community workspace and events and business support hub. And that will mean a lot of things, but one of those things will be providing workshops and programs for area businesses to help a broad range of different subjects. So we've done a few with Vermont Law, and they've been great. And today we have the honor of them joining us again. So the Vermont Small Business Law Center is the center that is putting these together and has some great services that they'll talk about later. Brian Bailey is a lawyer and teacher, right, Brian, at Vermont Law, and
Yep.
he will be guiding us today and having answering all your questions. And Devika Patel, sorry, I might have butchered that, is also joining him tonight. So like all webinars, it's all the same stuff. Please stay on mute unless you have a question. There's a chat if you would like to put any questions in the chat, though you're more than welcome to turn on your screen and either raise your hand or just jump in with questions as we're going through the presentation. This is really a free-form presentation, so if there's something that comes up that you have a question during, don't worry about keeping it to the end. So with that, I'm going to hand it over, and we're going to learn about intellectual property for your business.
Okay, thanks, Abby. Greetings, Cultivator. As Abby said, I'm Brian Bailey. I'm a professor at Vermont Law and Graduate School. We have with us today Devika Patel, who is one of our students, and Devika and I will work together to give some information and some education about intellectual property. So first, let's talk about what that might mean. So we're going to go a quick overview of intellectual property. What does this term mean? I think probably everybody has heard it, especially if you're in the business world. But what does that encompass? And what is sort of within the coverage of this term intellectual property. The three main ones, especially for businesses, are copyrights, trademarks, and patents. So if there's anyone who has a particular interest in one of these, feel free to put that in the chat and we can focus, more or less on one or the other, although I expect that we will have time to get through everything with some time for Q&A at the end for anyone who's interested. And when we think about Q&A, as Abby mentioned, feel free to jump in. That can be just with a note in the chat. I'm trying to sort of keep an eye on that on part of my screen here as we go, and Devika and Abby will be keeping an eye on it as well. Raise your hand, and by all means, just feel free to just come in using your voice and your camera as well, because these are more fun and I think more useful usually if we can have some conversation. But we can also have some time for questions at the end. So intellectual property, what is it? Well, we talked about copyrights, trademarks, and patents. We're going to talk about each of those in detail. There's more to it, right? So there's also trade secrets, which are really what you think. They're just secrets, unlike copyrights, trademarks, and patents. Trade secrets don't require a registration. Rather, they require a business to sort of hold things in secret, and we'll talk a little bit about that. And of course, the establishment of intellectual property is only one piece of what intellectual property means for businesses. It can also mean, okay, I've got a bunch of IP. what do I do with it? One of the main things that is done with IP is licensing. And of course, there's also the defensive piece, right? So when we think about IP, it's usually people are going to think about one thing or the other. Oh, I've got a great idea and I think I need a patent, or I'm building a really strong brand and I think I need a trademark. It might also be the case that someone else has a patent which is relevant to whatever you're doing, or someone else has a trademark that you would like to use, or you'd like to partner with them and merge the brands in some way, or somebody has a copyright that you need a license to. So that licensing piece can go both ways, and we'll talk a little bit about that as we go. Okay, so quick overview before we get into these in detail. And we're going to talk in detail about patents, trademarks, and copyrights. I'm happy to talk about trade secrets too. Those usually are less relevant for this type of group. So, if that's not the case, by all means, chime in, let me know. Otherwise, I'll just give a quick overview. So, patents. Patents are for things, right? They are intellectual property that can cover the thing itself. The thing can be a device, and that's the classic patent, right? It's the widget, it's the device, but they can also cover processes, right? So there's this idea of a method patent. That is a thing. We're going to talk more about that. And they can also cover things like compositions, right? Pharmaceuticals and so forth. Those are subject to patent with certain restrictions. Trademarks, on the other hand, that's about branding, right? So it indicates the source of the goods or services. When we think of ibuprofen, that's a drug. When we think of Advil, that's a brand of ibuprofen that only comes from one particular source, namely the owner of the trademark Advil, right? So words like Advil can be trademarks. So can things like slogans, just do it for Nike and so forth. Logos can be trademarks. By the way, this little TM here, that means that a business or individual thinks that whatever they've written down is subject to trademark rights. The circle R means that the U.S. Patent and Trademark Office agrees, and that there is a registered trademark, right? So as we're going to talk about, trademark rights can arise just by virtue of building a brand. But when those rights are perfected by a filing and a subsequent registration at the trademark office, then you get the circle R. Copyrights. Okay, so that's creative works, right? Works of authorship. The proverbial pen to paper, right? So when the pen meets the paper, copyright is born. It can also be for things like software and computer code. We're going to talk more about what copyrights are and what they do. And trade secrets, I mentioned these before. So they are sort of similar to patents in terms of what they can cover. There's processes and methods and information, right? This can be things like customer lists as well, which wouldn't be subject to patent. But it can also be the sort of secret sauce, right? The classic trade secret that most of us are familiar with, the formula to Coca-Cola, right? Coca-Cola is a trademark. The formula that creates Coca-Cola is a trade secret. And that's been a closely held trade secret of that company for a very, very long time. The key for trade secrets is that they are kept permanently confidential. One of the really cool things about trade secrets is that they can last forever. All right, so let's get into copyright. What is it? Copyright is all about creative expression, right? It's the expression of some kind of idea. So we think about authors writing books, right? They've thought of something, they put pen to paper, or these days fingers to keyboards, and they express whatever the idea they had is. And when they do that, copyright attaches, right? So the idea itself is not what is copyrighted, it is the expression. And so the way the law says this, works of authorship fixed in a tangible medium of expression. So that little bit of word salad has a lot that's kind of baked into it, right? What is a work of authorship? What does it mean to be fixed? And what is a tangible medium of expression? We're going to talk more about this Suffice it to say that copyright covers a lot of different stuff. So it's not just, classic books and so forth, right? It's also, as I mentioned before, computer code, music, photographs, videos, and more. Okay. So for example, right, when we think about the computer code, that code that it sort of expresses or is the culmination of some kind of business technique or business process, that's copyrightable. But the data and the correlations that lead to that, those aren't, right? That's just the idea. And we're going to talk more about the contours of that. A key thing to remember about copyright is that it happens automatically. It's immediate upon creation. So when that pen gets put to the paper and the words come out and the story is written, copyright has already attached to that. But it doesn't mean that it's been filed, right? So sort of like how I mentioned for trademarks earlier, there's this difference between the creation of the copyright, which just happens by virtue of the work having been made, and sort of the perfection of those rights, which comes from a filing, in this case, at a separate office, the Copyright Office, right? The filing is useful, but it's not required, right? So why file for copyright? Mostly it has to do with putting the public on notice that the copyright exists. And when that is done, if somebody goes and copies the copyrighted material, they're in deeper trouble than they would otherwise have been because they were on notice and it was a matter of public record that the copyright was out there, right? So basically, this is a matter of damages, right? Damages being the sort of legal term for how much money do you owe as a result of the bad thing you did. And the damages are larger when the copyright has been filed and accepted at the Copyright Office. Another thing that comes up a lot with respect to copyrights is this idea of works for hire. So this is another thing that's important to remember, and this also is going to be true for patents. Who owns the copyright? The default is that the creator owns the copyright. But most, if not everybody here or watching this after the fact, probably has a business, right? Many people have LLCs, or maybe there's a C Corp or whatever, some kind of a separate entity that exists for the purpose of running the business and is a different legal entity from the individual people who own or run the business. So this is an important thing to remember, because if the copyright inures to the benefit of the business, it's probably the case that the business should be the one who owns that copyright, but that is not the default. The default is that the creator owns the copyright, and for that to be changed, the creator has to assign the copyright to the business. That gets into this same idea of a work for hire, right? That's a way that the copyright can be shifted from the creator to whoever hired the creator to make the work. And we can talk more about that. All right, so let's talk a little bit more about what is this creative expression stuff. So I've mentioned how it's the creative expression, not the idea itself, which creates copyright. So one way to think about this, and this comes from a court case, mere diligence and effort, the sweat of the brow, is not sufficient to create copyrights. Okay, so what does that mean? Think about this, dashboard that we see on the slide, right? It's full of information. It's got charts and graphs and numbers and bits and pieces, right? There are a lot of correlations and information which was gathered to make something like this. And maybe some of those correlations are really novel and interesting, right? When we think about like the financial world, for example, somebody understanding a correlation between the price of oil and the value of a stock, that can be very valuable information. But those correlations and all that data that was gathered, that stuff's not copyrighted. What can be copyrighted, though, is the dashboard, the instructional, the thing created to display that data, to transmit that information, to convey those correlations to others, like the dashboard you see. right? So that underlying data, it might have taken a lot of time and effort to put all that together. And it might be quite difficult to sort of suss out what those correlations are. And there might be some brilliance in there too, right? That doesn't mean it's copyrightable though. Copyright is about the creative expression of the work. And so just saying, well, I worked really hard to gather all this data and I want a copyright to it. Sorry, that's not how it works, right? Just gathering the data is not enough. Okay, so we've talked a little bit about what copyright is. What about infringement, right? This is an important one, and it can be important for two reasons. It can be important because someone is copying your work, or it can be important because you're copying somebody else's work, right? And so either way, that's infringement. It's just a difference between whether you would be a plaintiff or a defendant. So what happens? How does infringement occur? It's a little bit of a slippery slope, and we're going to talk more about this, but the basic idea about infringement is that it's going to be derived from the actual copying of the material, the copyrighted material, and the extent of the copying matters because the copyright is subject to whatever registration, was put in there. Let's think about a photograph, for example, right? A photograph can be submitted to the Copyright Office and then be subject to a registration of the copyright. If the entire photograph is, copied and used on your website or whatever, then that can be an infringement. But what if it's part of the photograph? What if it's half of it? What if it's just, what if it's been cropped or something? Then, okay, less has been copied, right? And so there's this spectrum here. Also within the spectrum is what can we show about the infringer's access to the copyrighted material? Do we know that the infringer grabbed the material from the owner, right? And so did the infringer actually have access to that copyrighted material? So when we think about how much of it was copied and how much can we show about this access piece, it's this sliding scale. More extent of copying, less need to show access. Total, if it's obvious that access occurred and that, access can be shown clearly, the extent of copying can be less. Okay, so there's this sliding scale between these two factors. This raises the idea of fair use. And there's a lot of misconception floating around about fair use. What fair use says, it's what we call an equitable doctrine. It means, look, the law is the law, but we try to be fair. That's the equitable piece. Okay, and so there's this idea of fair use, which has grown up in the law of copyright over the years. And sometimes that can be a complete defense to an alleged infringement. Okay, so what is it? Well, it's a lot of things. It's sort of a fact-specific inquiry, and here's a bunch of stuff that goes into this analysis of whether fair use is an effective defense. Okay, so if it's just a little bit, right? That photograph we talked about, it's just a tiny little snib of the photograph. It's far from the whole thing, and it's the whole photograph that was subject to copyright. That could be a fair use, right? Another example of this, a little tiny bit of a song. We've heard this a lot, right? We hear it all the time on the radio, like on the news programs or whatever, where they play just like a few seconds of the song and that's it. Probably fair use, right? Because it's just this tiny little bit. There's also the question of, is the commercial value of the copyright being diminished by the use? In other words, is this a competitor who's using the copyright? So if it is, that's going to diminish the commercial value. So if a rival photographer grabs that photograph off the internet and presents it as their own, that's going to reduce the commercial value of the photographer who owns the copyright in that image, because they're both photographers and they're both trying to sell this to, within the marketplace of photography. What about how it's used, right? Other than commercial benefit. right? We're not trying to make any money off this. We were just using it for a PowerPoint presentation to a business incubator, right? For example. Okay, so that can be a factor. Using it to create a new work, right? This is this classic example of the soup can painting. I think probably most people are familiar with this Andy Warhol painting with the Campbell's soup cans. So, right, that Campbell's label is undoubtedly subject to copyright. But then Warhol took that and made a painting out of it, which has since become quite famous, right? That's like a predominantly new work. There could be arguments about whether that was fair use, but I think it's probably what was. Use for education, right? So classroom use and so forth, that's a factor. And critique and satire, right? So we want to protect the ability of people to use other people's copyrights as critique and to satirize them. Okay. So it sounds like, hey, fair use, pretty good, right? Like we're not going to worry so much about this copyright business because fair use. The problem is it's really not an insurance policy against infringement because it's a defense to infringement. And so the way I like to think about fair use, and I think a good way for business owners to think about this idea of fair use, it's a way to get you out of trouble, maybe. It is not a way to stay out of trouble because it's almost never clear cut. Oh, definitely fair use, right? Or definitely not fair use. It's this gray area. You have to look at all these factors and sort of make the best argument you can. There's lots of case law out there and so forth, but by the time you've gotten into that analysis, you're already into significant costs of defense, right? So even if you win, even if what you're doing really is fair use, that doesn't mean that the cost of defending a copyright infringement lawsuit are going to be trivial. They won't be trivial. I mean, there's going to be significant attorney's fees while everyone figures out what's fair use. So the goal for copyright is to avoid being accused in the first place. And we're going to talk about that. But in terms of fair use, right, here's a little list of really common misconceptions. Oh, I'm a nonprofit. I'm a 501c3. Therefore, I'm not making money and fair use. Sorry, no, right? Nonprofits do make money. They just can't distribute it to their shareholders. Nonprofits are in the business of, gathering money from folks just the same as other businesses. And definitely nonprofits are subject to copyright infringement lawsuits. Internal use, right? Oh, I just did this for like employee training. It's all internal. It's not up on our website. It's not anywhere else. Nope, that's not going to save you from copyright infringement. It might reduce the likelihood of getting caught, right? Because those materials might not make it out of the four corners of the business and come to the attention of the owner of the copyright. But that doesn't mean that copyright infringement hasn't occurred and that damages could be a result of that. And here's the big one. Content freely available on the internet, right? Oh, I just went to the website. I did a Google search for images and there it was. And I just saved it and I put it into my slide deck. Sorry, that's definitely not fair use. It could be, right? According to all the stuff we talked about, but that's not going to offer any protection just to say, oh, it was free on the internet. This is a major source of trouble for businesses. I have represented businesses who are in trouble for exactly this, right? Grabbing images off the internet, putting them up on their own website. It seems that, and I don't know this for a fact, but I'm pretty sure that there are probably AI-driven web crawlers, which are going around on the internet, finding images on websites, comparing those against copyrighted images, and then generating letters that say, you're in trouble now because you've infringed our copyright, right? And so I personally know of at least one law firm that appears to have an extraordinarily high volume practice doing this, right? They probably send 10,000 letters a year to people who published copyrighted images on the internet, and the bot found them, and now they're in trouble. So watch out for that. So how do you avoid that problem, right? Couple really good ways to do it. Creative Commons. So Creative Commons is a thing. You can look it up on the internet. It has a website. That is a place where creators can go and they can put their material. They can reserve some rights. They can waive all their rights. But when the material is within Creative Commons, the rights that the creator wants to retain are clear, right? And in general, it's going to be fine to just grab material from Creative Commons and use it, right? Because individual negotiations are not required. It's all right there in front of you at Creative Commons. That's a great place for stock images and other material like that. Oftentimes, the only rights that are being requested by the original creator and the owner of the copyright is attribution, right? No money necessary. By the way, there are other companies like the Associated Press, Reuters, the big news organizations. Associated Press in particular has like a really good and useful licensing tool. It's still like 25, 35 bucks for a basic license for like an image or something. But they have a very mature and automated system for getting rights. Also open source, right? Which is both an organization and a concept, right? This idea that the creator wants to open source their material. So, the product itself can include permission to use it. This is very common in computer code world, right? Where coders want to open source their material. They want people to build on top of it. And they in fact were building on top of the material of others, right? And so there's usually going to be terms and conditions that are established and communicated by the creator for this. And again, very often it's just, no, please do attribution. I'm not asking for any money. I just want other people to know that this is my work, right? So just do attribution. MIT has an open source license that is wide-ranging and encompasses a lot of material. So Creative Commons and open source are a great place to start if you're looking to avoid copyright infringement. Okay, so what do we do about copyrights? Well, when we're thinking about using material of others, think about who owns this, right? If it's a creative expression, if it's an image, a video, a piece of music, a website, something like that, somebody created it. Who owns it, right? The creator owns it automatically, but those rights can be assigned as we talked about. How did you get it, right? Was it through a Google search and it just popped up? Is it through Creative Commons, right? If you got it from someone who might be the owner, beware. And if it is copyrighted material, then it's a fair question. Well, what does the copyright cover? When we're thinking about images, for example, right? The photograph we've been talking about. What's the image you're looking at? Is it even the whole photograph? The Copyright Office maintains a registration of all this. Many, many, many things can be looked up at copyright.gov. So you can find out what the copyright covers, and we can find terms, as we discussed.
Brian, can I just jump in?
Yeah.
Because it seems to me like what you're talking about is all like 2D, or even the music, which can be written down. So it's on. Does copyright apply to like a physical creation, an artist creating, I don't know, piece of pottery or something like that? Is that under copywriting, or would that be something in a different category?
Yeah, so things do get a little complicated when we're talking about physical goods. So for example, let's think about the fashion industry, because the fashion industry is a big one and has lobbied hard to have copyright extended to include clothing. Copyright does not cover clothing, right? What it can cover is the patterns used on clothing, right? And so think about the classic Burberry check, right? It's that tan with the blue, and it's like certain kind of checkered with colors. That can be subject to copyright. The image itself, right? The actual sort of pattern of with the colors and the checks and so forth, right? And then that pattern can be applied to the physical goods. And in this way, copyright can be used to cover the physical goods. But that's the way that goes, right? So it's like the shape of something, right? Like I think Toyota might have pressed its case on the Prius in the early days. Like the Prius was such an unusual shape. And they wanted to say, no, 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 this shape of the car is copyrighted, right? This silhouette. Pretty sure they lost that one actually. You know, the Copyright Office is and you know the authorities that control it are pretty strict. This is going to be more. This is you know, let's go back, right? An expression of an idea. Works of authorship fixed in a tangible medium of expression. So what is that work of authorship, right? It's something, yeah, it can be 2D, or it can be music or something like that. What's the tangible medium of expression? Well, of course, it can be paper or something like that. It can also be, and this was a question at one point, it's not a question anymore, and hasn't been for a long time. What about computer stuff, right? What about is a flash drive or a hard drive or, you know, a compact disc a tangible medium of expression? Yes, it is. Although there was a time when that was a question. So
Okay.
it can get complicated. I think the classics are there. If it's getting into the more physical goods space, that gets to be a more fact-intensive analysis that is better to try to cover with an attorney.
Okay. So even extremely unique artistic or crafts, that isn't necessarily covered under copywriting just because it's like too hard to say that it is unique. Is that kind of my interpretation?
It's not a
there?
uniqueness. It has to do with this notion that an idea is being expressed in a tangible medium of expression.
Okay.
So when we think about like the pottery example, to use your example, right? So there are other options for that sort of thing. There is trade dress. So we didn't even talk about trade dress. It's sort of like trademarks, which Devika is going to talk about in a minute. But trade dress is the sort of overall appearance of something that's associated with the source of the goods. So a red can of soda with some swoopy letters on it, that would be a trade dress issue, right? If somebody comes up with something that, boy, that sure looks like a Coca-Cola can, but they're not using the words Coca-Cola, they're not using any of its trademarks, there can be a trade dress issue where Coca-Cola might still come after them and say, hey, that's confusing. People are going to think we made that. So like to the extent that pottery or jewelry or something like that has a certain look to it, trade dress can come into being. Also, we're going to talk about patents. Design patents can be a really useful tool for this kind of thing because those are designed to cover the ornamental appearance of something.
Okay. Great.
Of a
Thanks.
physical good. Yeah. So let's pause here. Do we have any questions about copyright before we move on?
There isn't anything in the chat. If anybody wants to unmute themselves, please do.
Very
Let's
well.
move on.
Hearing none, we will move on. We can come back to copyright if somebody comes up with a question. Okay, Devika, you're going to tell us about trademarks, yes? You are muted.
Yes.
There we go. All right. I will drive the slides, Devika, since I've been doing that already. So just let me know when you want me to advance.
Okay. So trademarks are a recognizable sign, design, or expression that identifies the product or service from other particular sources. So there are many different types of trademarks. So a couple are word marks, design marks, composite marks, service marks, and slogans. So using the Nike example from earlier, Nike's word mark is Nike. Their design mark would be the Nike swoosh symbol, and then their slogan would be just do it. So the purpose of trademarks is to identify the source of goods and services, to assure the quality and consistency so people can tell one brand from another, and then just to provide a legal protection of that brand's identity. Can we go to the next slide, please? So I've been using the term mark, but in general, mark just refers to all types of marks. So the term mark would refer to word mark, design mark, service mark, just grouping them all together. So this diagram we're looking at, this is the spectrum of distinctiveness, and this helps us describe the strength of marks. So this spectrum ranges from generic marks, which are typically never protected, to fanciful marks, which are protected from the very beginning. And the spectrum also indicates the scope of protection. And the higher you are on the spectrum, the stronger in terms of the owner's ability to enforce their rights against third-party users trying to use similar marks. The next slide, please.
Okay. Yeah, and I'll interject here real quick before we get into this and say one of the things that we talk to businesses a lot about is not getting too attached to a name or a slogan or whatever before finding out whether that might be eligible for trademark rights. Because by the way, also eligible for, domain names and internet stuff, right? So that's separate and apart from trademarks. But Devika is going to tell us all about this idea of distinctiveness, and some marks are registrable and some are not. And so getting a sense for whether the brand, the business name, the tagline, the logo is eligible for trademark is something that should be done early before the business builds up a whole brand around it, and only to find out that either they're running afoul of someone else's trademark that is very similar, or it's just not registrable because it's not distinctive.
Yes, so the different types of distinctiveness, we're going to start off with the very basic one that's generic. And these are just common names of the product or service that would be provided. And so generic words or phrases, they're so descriptive that they don't function as a mark. You wouldn't be able to get a trademark on them. So this would be the most difficult to register and enforce. So an example of this would be if a company sells gym bags, the company would have a very hard time trying to trademark gym bag just because it's too generic, it's not specific and too general. The next slide, please. The next distinctiveness would be descriptive. So descriptive words or word are merely describes an ingredient, quality, characteristic, function, feature, purpose, or the use of a product or service. And this also covers geographic designations and surnames. Descriptive words are not inherently distinctive and therefore probably most likely not able to be protectable as a mark from the beginning. However, there are words that may acquire distinctiveness, and that would be known as the second meaning. And this can be done over time through the use of the product or service and through promotion. And descriptive words can become protectable, but once protectable, it generally has the narrowest scope of protection against third-party uses. So for trade descriptive trademarks, it would have to have an association between the product and description. So an example of descriptive distinctiveness would be if there was a company called Quality Chairs, and if they were to sell chairs, the quality chairs would be a description of the goods being sold. But the Patent and Trademark Office would most likely reject this just because it's too generic.
They would just say quality just says what the chair is. Like it tells you something about the chair, not the brand, right? So quality TM chairs, no, we're not going to let you do that. But if you can respond to them and say, no. See, I can demonstrate that there is an association in the minds. People know this brand, Quality Brand Chairs. People know it, and you do all this stuff, right? This is a big part of what trademark attorneys do is build up this case for this public recognition of this what we call secondary meaning of the mark, right? And that's where it might be possible to convince the trademark office that they should let you have that trademark because the brand is so strong already that in fact there's already a consumer association between that word quality and the source of the goods. It's not just a descriptor of the thing, right? Chase Bank had to do this fight. So yeah, go ahead, Devika.
Can I have the next slide, please? Thank you. So suggestive trademark suggests a quality or characteristic of the product or service. And for this, it requires imagination or some sort of thinking by the consumer to connect the mark with the product or service. Marks in this category are inherently distinctive, but often difficult to predict whether certain wording will be considered suggestive or descriptive. So if you are able to get a suggestive mark, this would have a broader scope of protection than the generic mark or descriptive mark. And this is typically easier to get, and you would not have to show the secondary meaning. So an example of this would be Netflix. Netflix, one could probably guess that films or flicks are being transmitted over the internet, but it isn't quite clear as to if it's selling movies or renting movies or if it's just TV shows or just movies. It allows the consumer to do some thinking behind the name. So this mark would be offered underneath a trademark. The next one. So the last one on the spectrum in distinctiveness is arbitrary and fanciful. So arbitrary marks has a common meaning that has no relation to the product or service that is being used. It is a known word that is used in an unexpected or uncommon way. And in this category, marks are inherently distinctive and are offered a broad scope of protection. So an example of arbitrary distinctiveness, it would be Apple. They don't sell any type of fruit or food, which makes the use of Apple very arbitrary and distinctive. So because Apple sells computers and software and has nothing to do with fruits, they have a strong trademark right. For fanciful is typically a coined mark that is made up. It has no meaning behind it. It's completely an invented word. This mark are inherently distinctive, and because of their distinctiveness, it is generally offered the broadest scope of protection against a third-party use and the easiest to get. So an example of this would be the Xerox copier. That Xerox had no prior meaning before the formation of the company, and since the word was completely made up and the general public, when we see Xerox, we think of the copier. They have the fanciful distinction and the easiest trademark, so they have the most protection underneath it. The next slide. So why
I'll say
sorry.
a quick thing about this fanciful too. this is why drug names are all full of X, Y's, and X's and Y's and Z's. It's really easy to get a trademark when the drug name, is this crazy word that no one has ever heard, that has never been used in any language ever in the history of the world, right? And so that's a big part of the reason why they do that. I mean, maybe it's a cultural thing now too within the industry. I don't know. But it is the case that trademarks are really easy to get. Also, something we didn't really cover here, but is kind of just an interesting aside. When you think of Xerox copiers and Xerox copies, I mean, these days we don't use paper anymore. So people are probably not calling things Xeroxes anymore. And maybe I'm betraying my age, but once upon a time, people used to say, oh, Xerox that, right? And another more contemporary one that we have used a lot of in the last 4 years, Kleenex. People say, oh, can you hand me a Kleenex? Kleenex does not want you to do that because Kleenex is a brand for tissues. And if it gets to the point where it becomes a generic term for the thing, you can lose your trademark rights. This is probably not, this is a nice problem to have for a business, right? You've become so ubiquitous that people say, oh, hand me a Kleenex. And you're like, oh, we're losing our trademark because it's become generic for this little square of tissue that you pull out of the box. So what started out a completely fanciful term that was never a word anyone used becomes a generic term. It goes to the other end of the spectrum because it becomes in such widespread use that people start calling all tissues, regardless of source, Kleenex. So that can be a threat to people's trademarks. Not a problem for most startup companies, but something to just be aware of. Sorry, that's my aside.
No, you're fine. So why do we have trademarks? So trademarks are really to protect your brand against knockoff brands or similar brands. It just discourages other businesses to try and make copycats of your brand. And it helps consumers to find your product and avoid the overall confusion between goods of services that are similar to yours. And just a couple of side notes, trademarks are more appropriate for public marketing versus internal marketing. So trademarks really help when the product or good or service is out in the public for everybody to use and not just an inside company thing. That is all I have on trademarks, I believe.
Yes, looks
Can I
like we're
ask
headed to patents. Yeah, Abby.
just a quick question? Because, I mean, it seems like this would not be a step that a lot of small businesses would be making. Is there like a tipping point or a suggestion of when you would move into like wanting to pursue trademarking your brand and your name? Oh, shoot.
Yeah, I could speak to that. I mean, that actually raises a point that I wanted to make, which is I talked about how trademarks copyrights are automatically created. Trademarks can be like that too, right? So trademarks, the brand can be built with the little TM rather than the circle R, right? And so any business can start using that TM, and I submit probably should start using that TM with anything that the business thinks would be a trademark right in the future, right? So brand identifiers, slogans, taglines, um, um, logos, and the like. Okay, so sticking that little TM on there is kind of a good idea because it lets the public know, hey, that's our territory and we will defend it if we have to. But then the question becomes, well, at what point should a business undertake the expense or hassle of registering a trademark, or for that matter, a copyright? There's no easy answer to that question. When it comes to copyrights, I will say those are pretty easy to DIY. A copyright registration, I think most entrepreneurs can probably make their way through a copyright registration on their own. The fees are pretty minimal. I don't know what they are, but it's like $100 or maybe less. Trademarks are a little harder to DIY. Not impossible though, especially once you're armed with the information we've just given you, right? So if you're going to try to trademark Apple brand apples, yeah, that's not going to go well for you, right? But if you're somewhere along that spectrum of distinctiveness, hopefully over towards the fanciful or arbitrary side, or at least getting close to that, it's probably going to be a relatively easy thing to do. There are some questions about, what kinds of goods or services do you want to cover? You have to choose classes and so forth, right? So when Apple goes to apply for its trademark, it's being careful to say this is for computers and computer services and computer peripherals. And so they're going to include all that in phones, right? And tablets and all that. They're going to include all of those in the classes of goods and services that they're trying to cover. And they're specifically not going to say that this is for food, this is for fruit, this is for farmers market services or something, right? They're not going to cover any of that in what they choose for their goods and services that they tell to the office. So trademarks are somewhat more DIY-able. The filing fees are a little higher. It's $250 per class. Sometimes you'll need 2 or 3, 4 classes. Also, something to keep in mind with trademarks, there has to be a use in commerce shown to the trademark office, and that has to be true at the time that the trademark is registered, and also periodically upon re-registration, right? So that you have to redo it every, handful of years. I think it's year 5, and then year 10, and then every 10 years after that. So trademarks cannot be just like kept and held to a company. They have to be used. And some sort of demonstration of the use of the trademark will have to be shown to the patent office. So that's kind of the flip side of, if you build a brand, you kind of automatically have trademark rights that you can just go register and get your Circle R. But what you can't do is think, oh, I'm gonna build this brand in the future and I want to reserve this name for myself. Nope, can't do that. It has to be in use, right? There has to be actual goods and services associated with the trademark that correspond with the goods and services that are being claimed in the classes set out to the trademark office. So when to do it? I mean, I think the important takeaway is copyrights and trademark rights automatically accrue as a virtue of making the creative expression or building the brand, respectively, right? Copyrights former, trademarks latter. Registration is good when the brand is getting widespread enough that there might start to be copiers, right? So because in both cases, copyrights and trademarks, it's not enforceable, all right? You can't address copying behavior and knockoff products unless a registration has been obtained. And here's the issue. Many times businesses don't know that copies are being made, right? And sometimes this goes on for a while. It might go on for years before the business finally gets wind that somebody's making knockoff products, right? So the problem with not having a registration is that in that type of situation, what's going to happen is the business is going to say, oh crap, we have a knockoff situation going on. They run off to the attorney, they get their trademark registration. It takes a while, by the way, 9 months or so. And then they can haul off and sue the infringers of the trademark. But all the infringement that's been happening up to the date that the registration is granted, not much you can do about that, right? The damages are really minimal. Same thing with copyrights. If it's an unregistered copyright, the damages are limited to, like actual losses. Whereas, right, so basically you have to sort of prove up, well, I would have made this many sales had you not infringed my intellectual property, but instead, you are infringing, so you just owe me the money that I would have made. Okay, great, that's better than a sharp stick in the eye, but it's not nearly as good as if you had a registered copyright where you can go after what's called statutory damages, and you can say, no, you knew what you were doing is wrong, or you should have known because My copyright was out there for all to see. It was registered at the Copyright Office, and now I get to bring the hammer down on you and get what's called statutory damages, which can be huge and very punitive, right? It's the same thing with trademarks. You can get these punitive damages where you're saying you're not just gonna, make it better for our business because of the bad thing you did. You're also going to pay a lot more on top of that, so you'll never do it again. That's what a registration gets you.
Okay, thanks.
All right. Any other questions on trademarks or copyrights before we move on to patents? I know this is interesting to at least one of our folks here. Okay.
There's nothing in the chat, so.
Hearing none. Patents. Okay, patents are the most powerful, I submit, form of intellectual property. And that is because they cover the thing itself. So copyrights prevent people from making copies of the copyrighted works. Has to be, as we discussed, something close to an exact copy, or, there's the fair use, but it's pretty limited, right? It's pretty much knockoffs. Same thing with trademarks, right? They prevent consumer confusion. If there's a likelihood of consumer confusion as to the origin of the goods, the trademark has been infringed. So there's some latitude there, but it's not a lot, right? I mean, basically, you have to show this likelihood of confusion. With patents, though, it's for the thing itself or for the method itself. And we're going to talk about claims, but basically what the patent claims is protected, and no others can make or use or offer for sale or sell, in fact, or import the thing covered by the claims, or the process that's covered by the claims. And so how does this work in real life? Let's say it's a thing, right? It's a widget, and you've got a patent for your widget, and you have broad protection in a patent. And then someone starts making it. It's not quite the same, but it's basically the same, and it is the same basic concept as the one that you invented. You can buy one of the widgets from your competitor, and you hold it up against the claims. You've got widget in one hand, claims in the other, and you say, all right, does the widget have all the features that are listed in my claims of my patent? And if the answer is yes, it infringes, and you get to go after them and seek large damages. Okay, so the beauty of that is that a clever patent drafter can get claims which are very broad. If in fact what you have is a brand new invention, something that no one has ever conceived of before, it is totally new, then very broad coverage over that invention might be available, and only a patent can get you that. Okay, so we're going to get into the details of that. Right, so what do? They offer this right to exclude others from doing all these things, and they do that for a term of 20 years from the original filing. One thing to note here, when a patent application gets filed, that's just the beginning of the process. It sits in queue usually for a couple years these days. It's getting a little shorter, maybe a year and a half. And then an examiner picks it up and reads those claims and reads the whole thing, and usually gives you some rejections, and you get this negotiation back and forth with the examiner. Typically, the actual enforceable life of a patent, more like 17 years, because it takes a few years to get the actual patent from the date that you made the original filing. Okay, so we've seen what patents can do for an owner. What don't they do, right? Again, misconceptions run pretty rampant here. They don't give anyone a right to do anything. They give you a right to exclude others from making or using or selling, etc., your invention. But they don't give you a right. There's no, sort of federal sanction to make your product or whatever, or practice your process just because you have patented it, right? So it's not regulatory approval. It's not affirmative permission, really, of any kind, right? The government hasn't said, cool, you can make it, without any interference from us or anyone else, right? All they've said is it's novel and non-obvious, which we're going to talk about. So what do you get? Well, you don't get access to government enforcement mechanisms except the courts. And in some cases, import authorities, because we talked about you get to prevent others from importing your inventions. So there are some import authorities, and you can have, those people go and like stop the stuff at the border. But other than that, it's the courts. What don't you get? The police, right? You don't get an ability to like use the government to crack down on infringement. That is the job of the patent owner, and the mechanism for doing that is lawsuits, right? So that's when a business owns patents, its job is to enforce those patents. So it's kind of a whole ecosystem, and we can talk more about that. Okay, so we've been talking about patents generally. This goes to your earlier question, Abby. There are two kind of main patents that are relevant to most folks. That's on the one hand, a utility patent, and on the other hand, there's a design patent. There's also plant patents, by the way, and if anyone is interested in plant patents, we can talk about that, but most people aren't. Plant patents are just particular to sort of the industry of breeding, like the latest and greatest apple, right? The next Honeycrisp or something. There are patents available to those folks, but that's pretty narrow. But I usually don't cover them. Utility patents are what most people think of when they think of a patent. It's the document that protects the thing itself, right? I like to use the example of like a stool, right? Let's say that no one has ever invented stools before. Everybody was sitting on the ground up until the time that the inventor came around, and the inventor invented the stool, right? And so the patent says, we've got at least 3 legs, which extend down from the sitting platform, and, maybe some other details about how the legs interrelate and how they're fixed to the sitting platform and so forth, right? That can be a patent, and anyone who makes anything that includes 3 legs and a sitting platform and the other details are covered, they're going to infringe that patent. That's a utility patent, right? Methods, by the way, can be protected too. So methods used to be the way that software was protected. This is relevant to a lot of small businesses. Software these days is disfavored. A change in the law happened, I guess, about 12 years ago now, that eliminated a lot of software patents because they were causing problems. Software patents were method patents, and they still are. There still is such a thing as a software patent, right? That is, take data in, process the data, and create an output, right? Switch the switch, turn on the fan, activate the anti-lock braking system, right? Those are method patents. We're not talking about what the thing is. We're talking about how it works. That can be done too. So we talked about how you can sometimes get very broad coverage using utility patents. We also talked about how enforcement really is the patent owner's responsibility. So why get them? They can be extraordinarily valuable, especially for tech-focused companies, who are trying to attract capital, right? Either by, usually in the early days, that's with venture capital, for example, maybe if things are going really well, try to go public, right? So patents can be, especially for companies that are based around some kind of invention, patents can be the single most valuable kind of IP that there is. Warren Buffett talks about moats, right? He has this idea, right? Warren Buffett, classic investor in companies small and large, and he wants to give money to companies to help them grow. How does he decide which companies to give money to? He looks for moats, among other things. What does that mean? It means that you've got like the business, think about the business sort of sitting on an island, and it's built a moat around itself that's full of sharks with lasers on their heads or whatever, right? And you can't get to the island of the business without crossing the moat first or getting permission, right? So the company will lower the drawbridge and let you over for a fee, right? A license fee, for example. Otherwise, you got to swim with the sharks. Good luck with that, right? So that's what patents do. They create this moat around the business by excluding others from competing with that business for 20 years from the date of filing of their original invention, right? So it gives the business this 20-year lead ahead of everyone else, assuming that the business has an invention. So we're going to talk more about how you get that, but that's what utility patents can do for a company. They can be very powerful. However, unlike trademarks, and it's definitely unlike copyrights, they are not DIY friendly. There are many traps for the unwary in preparing a patent application. And I won't say it's impossible. It's not impossible, but it's not easy. And that is largely because when a patent application is filed, it is set in stone and it cannot be amended except for the claims. So everything has to be done right upon filing. Okay, that's enough of that. Design patents, what are they? They have similar rules to utility patents, but they're about protecting the ornamental appearance of the thing, not its function or the way it is used or whatever, right? So the way design patents are much easier to prepare because we're not describing, the function and the structure of the thing anymore. We're just showing it, right? We need really nice drawings, basically is about what it boils down to with a good design patent. And there is still strategy there, but it's a lot simpler to figure it out. So they are easier and less expensive to prepare. They do offer somewhat narrower coverage, but it can still be pretty valuable. So the example of a classic design patent, we talked about Apple brand computers. Apple is a very good IP company. They know what they're doing. They got a bunch of design patents for the early iPhones, right? And at the time, like, what even is an iPhone? It's like this box, right? And it's got the one little button on the bottom, and I guess it's got the little slit on the top. I think the early ones didn't even have a camera yet, right? So it was just like this box. And the thing about the early iPhones is they weren't that innovative in terms of their actual technology. Most of the like internal bits and even the software and stuff, like others had done that, right? There were other things that had already been invented, which had all the various parts and pieces of an iPhone. But it definitely looked different from everything else that came before it. And so they had all these design patents. And when Samsung came around and started making their smartphones, Apple sued. And they said, that's an infringement of our design patent. Samsung, as you would expect, mounted a vigorous defense saying, no, our thing is different. It's bigger and like the button looks different and, all these details. And in fact, I think it would be probably fair to say that at least a tech savvy person in the early days of smartphones would have been able to tell, and still probably can tell the difference between an iPhone and a Samsung phone, right? They're not the same. They look different, but Apple won because nothing had ever been done like that before. So their design patents rendered this massive judgment against Samsung. And the reason is because, they did infringe, right? Because the ornamental appearance of the early iPhones was something truly new, and Samsung knocked it off. All right. So how do you get a patent? Well, it's got to be new. It has to be an invention. So what does that mean? Well, first of all, it means it has to be what we call novel. Novel means that it's never been done before in the history of humanity or the world or the universe, right? It's new. And so this gets down to the claims, right? And trying to figure out like how we're going to claim this to make sure that it's new. But let's pretend that my three-legged stool is new, right? If someone can come up with a reference that shows a three-legged stool that's got the three legs and the sitting surface and the legs are fixed to the sitting surface and the other details that I've claimed, and they say, wait, I've got a publication here It's an earlier patent, it's a YouTube video, it's something on the internet, it's a white paper, right? Some earlier thing that says, nope, you didn't invent it. Someone else got there first, no patent, right? That's a lack of novelty. So a single, well, this is what we call the prior art, right? It's that body of literature that shows us what came before in the world prior to our filing date. So if a single prior art reference comes up that shows a stool with 1, 2, 3 legs and a sitting surface and the other things that I've got in my claims, no novelty, my patent is rejected. Actually, it's worse than that though, because it also has to be non-obvious. This is where sort of inventiveness comes up, right? It's kind of this adequate distance beyond or above whatever the state of the art is, right? And so the way this works is you get examiners who combine two references, right? And so let's say that I get a rejection on my three-legged stool, and the prior art reference was a green stool, and I have support in my specification for lots of colors other than green. And I say, okay, I'm going to change my claim to say 3 legs, sitting surface, etc., and it's blue, right? Now it's novel because the prior art didn't show a blue one, it showed a green one, right? And so I've met the novelty standard. That's new, right? You can't show me a reference that has a blue 3-legged stool. And there isn't one out there. By golly, I'm the first one. Well, the examiner can go pick up a second reference that says, hey, things that are green can also be made blue, right? And the first reference that says, hey, I've got a green stool, and they combine the reference and say, it would be obvious, right? It's obvious to change the color. Anyone can do that. So that's not inventive, right? Just because you made it blue doesn't make it inventive. People know how to paint things, right? So that's a simple example, but this kind of argument plays out all the time. This is a big part of what patent attorneys and agents do, is argue with examiners over what is and is not obvious. And one of the reasons it's important to write a good patent application in the first place is to anticipate what kinds of obviousness rejections might come and be ready to amend claims or make arguments that refute the examiner's take on what is and is not obvious. Okay, what else do you need for a patent? Well, some things are eligible and some things aren't. What's eligible? New and useful, process, machine, manufacture, composition of matter, or any kind of improvement of all that stuff, right? So we kind of talked about all that. What's not patentable? Certain things are excluded on grounds of public policy. Living beings, right? I got this great new puppy. I want to patent it. Sorry, it's a living being, can't do it. Naturally occurring substances. Hey, I found that if I chew on this certain kind of bark, great things happen for me, right? I want to patent that. Sorry, it's a naturally occurring substance. Now, talk to the pharmaceutical industry, and they will find ways to distill the stuff out of the bark. This is how aspirin was invented, right? Aspirin came actually from the bark of some tree somewhere. And some clever people figured out what, so indigenous people from, thousands of years have been chewing on this bark to alleviate pain. Great, not patentable. However, if then, pharma company comes along and says, there's something to that bark, let's get some of it and bring it back to our labs and figure out, like, what is the actual substance which is causing pain relief. And this is how aspirin was born. And they isolated it and they purified it and they put it into a pill. That can be patentable because it's not the naturally occurring substance anymore. It's like a refined version of that that's been changed, right? Scientific principles, right? E equals MC squared. That was a big deal when somebody figured that out. It's not a patent. Machines and processes which arise from that idea can be patentable, but the actual principle, I claim E equals MC squared, nope, can't do it. Laws of nature, similarly, right? Like I know I figured out how fast gravity is, right? How fast it makes things accelerate. I want to get a patent on that. Nope, that's law of nature, can't do it. Abstract ideas. This is where software got tripped up. So software patents used to be pretty widespread, and they aren't anymore. And that is due largely to a change in the law, which said actually many of these software patents are abstract ideas. There is a whole body of law built around this. And within the specialty of patent attorneys, there's a whole subspecialty of patent attorneys who work on software inventions. So suffice it to say, this is a complicated area of the law. One way to think about this, because I know software patents are interesting to a lot of people. If you can think your way through the entire claim, it's probably not patentable, right? I receive information, I process the information using math and an algorithm, and then I think about an output. And I have this idea of an output, which comes up. That's not enough, right? Now, once you switch the switch, turned on the fan, done something like that, okay, maybe you got a patent. But before you get to that point where you're changing something in the physical world, it's an abstract idea, not patentable. Okay. This is a big one. For anyone who's interested in patents, if you take one thing away from this discussion today, this is the one. When do you file a patent? Well, ideally, you file your patent before any non-confidential disclosure of the invention to another. So let's pause and think about what that means. Well, I told my brother-in-law about it. Is that confidential? I don't know. The best thing to do would be to put your brother-in-law under a non-disclosure agreement, and then it's confidential, right? Well, I gave a presentation to a group of about 100, and in that presentation, I talked about my invention. Is that a non-confidential disclosure of the invention? Quite possibly, yes. It depends on how much you said and what you intend to claim. What is the invention after all? But making that non-confidential disclosure jeopardizes patent rights. So if worldwide patent rights are what's of interest, the entire thing should be kept under wraps until a patent application has been filed. What do we mean by under wraps? No non-confidential disclosures. How do we do that? Non-disclosure agreements for everyone who gets to know what the invention is, right? And by the way, the non-disclosure agreements protect patent rights, but only if the counterparty to that agreement keeps it confidential. If you put a prototyper, let's say, this is a common thing, right? People say, oh, I need a prototype. Oh, well, I can't make a prototype, so I'm going to have someone else make it. I'm going to have to disclose the invention to the prototyper. Let's put the prototyper under an NDA. All good stuff. That should be done. If the prototyper then makes a bunch of them and puts them on the internet, that's a non-confidential disclosure. Patent rights are lost. Now, there's probably a cause of action against the prototyper, but sorry, no patent. So keeping it under wraps is a key strategy for patents, and using NDAs is a way to show that it was kept under wraps. Okay, now the good news. Yeah, Abby.
Just 2 points on there. So is just saying like the general idea, because obviously when you're, let's say, pitching to VCs or something like that, you have to explain it to a point. So if you're just saying that it's a patent pending process to do whatever, is that too specific? Do you need to be even more general, or will it really matter on the process itself?
So if it's patent pending, you're all good.
Okay,
right?
sorry. If it's not patent
But if
pending.
it's not yet patent pending, then there are ways to say stuff without disclosing the actual invention. For example, you could say, I've got, so Carolyn wants to know, is it a provisional versus non-provisional? That is a good question. We will come back to that in a second. The short answer is it doesn't really matter. A provisional is protective, can be. So, but let's say no application has been filed. It's fine to say, I have created a vehicle which is self-driving and which can achieve a perfect safety record at speeds of 100 miles an hour or less in any circumstance. Please give me money, venture capitalists. That isn't disclosing the invention, right? The invention is, how did you do that? And what you're going to claim is how you did it, right? And so there's going to be lots of technologies which enable that result. And so talking about the results you can achieve is a good way of talking about something without talking about the invention itself.
Okay, so the result, that's a good point. And then the NDAs, really, are those can be as simple as just like drafting something yourself? Are there different ranges? Like if you have it drafted by a lawyer, is it more enforceable versus something that's just like downloaded offline that you find?
So what's important is confidentiality in fact. And what an NDA does is provide really good evidence that the disclosure was confidential, right? So what the NDA does, it does a couple things. First of all, it's evidence of confidentiality, which is going to be good enough for the patent office or the courts if later the patent is being challenged based on some earlier disclosure. As to the content of the NDA, you know, there is a better and a less good way to do it. And so I think that a DIY NDA that says, I'm disclosing to you my ideas about this, and you agree to keep these in confidence, and we both sign on the dotted line, that's a heck of a lot better than nothing. There are other things that NDAs can do, right? Like establishing, okay, if you do breach this agreement, then what happens? If sometimes we get into situations where we're signing NDAs because we're going to collaborate, then the question becomes, who's the inventor at the end? Sometimes NDAs will include assignment rights in there. You know, we're all going to collaborate, but I'm bringing this to the table, and whatever we come up with, I own it, right? I mean, that can be in an NDA. So there are plenty of things that can go in there, which can be valuable to the business, but any kind of writing is way better than no writing. As long as it expresses that, you know, everyone's going to maintain confidence. Let's come back to Carolyn's question about a provisional. So a provisional application is a precursor to a utility patent application. It's maybe worth noting that provisionals are not used for design applications. What a provisional application does is it holds your place at the patent office for a year. But the provisional is not examined, right? So there's no formalities. It doesn't enter the queue for examination. An examiner is not going to look at it. What that does is it provides a cheap and relatively easy mechanism for depositing with the patent office your idea, right? And so you can just sort of write it up and send it off. The filing fees are cheap. I think it's like $160 now for a small entity, which is basically a company with 500 employees or less. And it holds your place for a year. And then at the end of the year, a regular utility application with all the formalities and everything has to be prepared and filed. So both of those can be protective from the perspective of having a filing in place before a non-confidential disclosure. The asterisk that I will put on provisional applications is that these days they better be good, because they have to end up supporting a claim. And the reason for that is we are now in so in the United States and in other countries, we're in what's called the first to file regime of patents. It used to be, in the old days, and I'm giving me my age again for people who know this stuff, that you could show that you were the first inventor. And even if you got to the patent office late, that's okay. You could come back and say, no, no, no. See, look, I've got all these journals and all these lab notebooks and everything, and I can show you that I was actually the one who invented it first. That does not matter anymore. What matters now is you won the race to the patent office, right? So here's a scenario that could happen. A quick and dirty provisional is filed. It doesn't include much in the way of descriptions. And then you go public with your invention. Now a bad actor uses the information you have provided to them and files their own patent application. And theirs is good. It's professional and it's complete. You go to file your utility application a year later, you make it professional and complete, but guess what? That earlier filed one is going to be prior art to you. Now, if they stole your invention, there are recourses for that, right? You're not allowed to steal inventions, but you don't want to be in that situation. So provisional applications should be quality. They can have informal drawings and they don't have to have like a fully developed set of claims, and they can be less complete, but they should include a really good description of what the invention is. So that's my note on provisionals. But to answer Carolyn's question, a provisional, perfectly fine for protecting patent rights. It does not have to be a non-provisional full utility application to protect rights. Does that answer your question, Carolyn? Probably more than you were looking for. Yep, awesome. So let's talk about the good news, because I've now scared everybody about patents by talking about non-confidential disclosures prior to filing. Well, there's good news. In the United States, you get a 1-year grace period. So what that means is you get to make a public disclosure. And if during the 1-year period following your public disclosure, you get your application on file, you still get to have your patent rights. This only works for certain countries. This is the flags I put there. Canada, United States, and Mexico all have this 1-year grace period. I think Australia still has it as well. Many, many other countries do not have it. And that includes Europe, includes China, it includes Japan. Those are absolute novelty countries, which means you have to have your filing in place before you make any public disclosures. So the 1-year grace period is very protective. A good patent attorney is going to be asking aspiring patent applicants, have you had any disclosures? Have you talked to anybody about this outside the company? If so, did you have a non-disclosure agreement? And when did it happen? Right? Because we're going to docket the 1-year anniversary of that date and make sure we get our filing in place. So for most patent applicants, including especially patent applicants residing here in the United States, a US patent is going to be really valuable and is going to do a very good job of protecting the business. Foreign rights, I get this question a lot. Well, should I file worldwide? How much do you want to spend, right? Pursuing worldwide patent protection is an extraordinarily expensive proposition. Even the major multinational corporations don't pursue worldwide rights. They pursue rights in a lot of countries, but they still pick judiciously, because let's just talk cost for a second, right? I mean, what does it cost to file a patent application? Well, it depends on who's drafting it, right? But I think having a professional patent application drafted and filed can easily run to $10,000. It can be done cheaper. Sometimes it costs more. It sort of depends on how much due diligence is being done ahead of time, and how complicated the invention is, how close the prior art is. These things are all relevant, right? That's just through to filing. And then prosecution, right? Negotiation with the examiner, it could cost that again if it's a tough prosecution or more, right? Sometimes you have to like appeal the examiner and go to the board at the patent office and so forth because the examiner is being obstinate or won't agree with your position. So it can be a pretty expensive game. And then when you add in, say 40 countries, right? Take those numbers and multiply them by at least 40, because it's actually going to be more than that because you need counsel in the foreign country. I'm a US attorney and I cannot file a Canadian patent application. To do that, I send the application that I've drafted to Canadian counsel and they file it for me. Is it true that 95% of first patent attempts are rejected? Yeah, that sounds about right to me. Rejections are the norm by far. In fact, if you get to a patent examiner and the first action they give you is, cool, looks good, patent granted. The first question I'm asking is, oh man, maybe we didn't ask for enough, right? The way patent claims are usually drafted is you're going to try to get broad coverage over the basic idea or sort of the broadest conception of what the invention is. And then you're going to narrow that coverage down with what's called dependent claims. And then that's going to form the basis for negotiation with the examiner. So hopefully you're asking for absolutely as much as you think you can get. And then the examiner is usually going to come back to you and say, yeah, that's too much. I'm not going to give you that, right? Okay, fine, it's novel, but it's obvious, right? I'm going to find 2 or 3 or 4, sometimes 5 references, right? They'll just string them together and say, I'm going to find all the parts and pieces in the prior art. And over in this 5 reference combination, I'm going to say it's obvious. And then we're going to come back and say, come on, that's ridiculous, right? And we're going to have that fight. But it is true. Yeah, I would say 95%, that's 20 to 1. That sounds about right. Yeah, I don't see very many come back with a first action allowance. Hopefully, though, one set of negotiation with the examiner and you're good, right? That's when things are going well. You do one response to the examiner and you got your patent. By the way, we haven't talked about this. We've got some time. I'll just mention this. How do you try to make sure that you are novel and non-obvious? How do you do that, right? How do you write an application that's gonna get favorable examination? One big way to do that is understanding what is in the prior art. There's this whole industry out there for patent searchers. Most of them are former patent examiners, and they open search firms. And their whole job is to search for prior art. You describe your invention to them. They're under an NDA. And you say, this is my invention. This is kind of my idea for how I would claim it. Go find me prior art. And the patent examiner, the searcher, does exactly what patent examiners do. They go off and look for prior art that will destroy novelty. And if they can't find that, they look for prior art that will give them a good case on obviousness. And then you look at the prior art and you think, all right, maybe the invention isn't quite what we thought it was. Maybe we're going to need to claim this different. And this is where a good communication between the patent drafter and the inventor is key, because the drafter is going to come back and say, I don't get it. Like, I would reject your claims. I don't see how you have an invention. And then the inventor can come back and say, no, 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 no. See, that's different. And let me explain to you why it's different, right? What we've got does this really cool thing. And that prior art wouldn't do any of that cool stuff. And now the patent drafter's like, oh, all right, I get it. I'm going to tell that story in my patent application, right? So that's a really good process. Is, you get a search done, you look at the prior art, you have this discussion with the inventor, you kind of come up with an idea for what you think is patentable and what the sort of story is there, and then you tell that story to the examiner in your application. If you do all that, you're going to get better results on average.
Just a quick question there. Not that anyone would want to do it, but it's all public knowledge to do those searches, those previous searches
Yes.
of patents. Okay.
So yeah, the question from Carol, what's the cost, right? I would typically authorize a professional search firm to spend between $1,000 and $2,000 for like a typical invention. But before you even get there, you can go off and do a search. Google Patents is a great resource. Just Google Patents and it'll come right up. It's a patent database maintained by Google, which is searchable using Google's search algorithms, and it's very useful. The USPTO itself also has their search tools used to be just okay. They've gotten better. So uspto.gov is an extraordinary resource actually for people who want to file patent applications or trademark applications, and they have tons of information and they have a really good search tool. So the first thing an inventor can do is go out and search on their own, right? And it's not just patents either. I mean, prior patents and patent applications are a very fertile territory for prior art searching, but anything can be prior art, right? It can be scientific papers, it can be websites, it can be YouTube videos. And I've seen examiners use all that stuff. So the idea is to figure out, okay, what's out there and what aspects of my invention are already known to the public, that is to say they're in the prior art, and then what is left, right? Like if you've still got this kernel of the idea where you're like, but I didn't find anything that's like the core of my idea or my invention. Maybe you got a patent there, right? And maybe you take it to the next step and get a professional searcher to try to find the stuff you couldn't find because it's a lot, right? I mean, there's more than 10 million patents just in the US alone, plus worldwide, there's many more millions of patents besides. They can search all of those and find stuff that maybe you wouldn't be able to find using their magical patent examiner skills and knowing how to use the patent system. By the way, the whole idea behind this patent stuff is that it's a quid pro quo between the public and the inventor. So we, the public, through our Constitution and government, laws and regulations built up around it, because the patent system is a constitutional system. We're letting people have 20 years of monopoly around their patented ideas. What are we getting in exchange for that? We're getting disclosure, right? We get to search 10 million patents. I think we're up to 11 almost, or maybe we've crossed 11. We can search for those. That's freely available. We can find ideas within the patent system. And very often I find this happens, right? You get inventors who start looking for prior art, and what they find is better ideas, right? And they look at something and say, okay, well, they already did it this way, and that's interesting. But now that I think about it that way, I'm going to do it this other way. And they can improve on this body of knowledge that is contained and encapsulated within the patent office. So the patent office is a pretty good place to look for not just prior art for your inventions when you're trying to figure out if you have a patent, also looking for ideas, right? It's this repository of knowledge, of technical knowledge, and it's supposed to be used that way. So this is a perfect time to talk about our service, right? So I'm coming to you from the Vermont Law and Graduate School, where I'm a professor. I'm also a solo practitioner here in Vermont. If you can't tell, I do patents and also other intellectual property stuff. What do you do, right? We've been talking about how expensive this stuff is. What do you do if you're just a startup? Well, if you're a Vermont startup, you qualify as by virtue of being a small business in Vermont. You can get 10 hours of free attorney help at no cost to you. We have a grant that we administer through the law school that is used to pay the attorneys. We call it a low bono rate, so it's not quite pro bono. The attorney is getting paid, but it's It's much less than a typical rate, but it's not nothing. And you can take advantage of that. And I have done this for people where, for a simple invention in 10 hours, which is the amount of time you get, you probably can get a patent application just about filed. So, that's working efficiently. They usually take longer than that, but certainly can get far down the road. It doesn't have to be patents or any intellectual property, any legal needs at all, right? So we got a lot of people who are just trying to incorporate their business and trying to figure out, do I do an LLC? Am I going to be a nonprofit? Should I be a corporation? If I'm going to be a corporation, should it be in Vermont or Delaware, right? These are things an attorney can help with, and you can use the 10 hours for that, or for reviewing a lease agreement, or for reviewing some kind of other agreement that's with vendors or whomever, whatever you need. So we offer this program. It's been super popular, which makes sense because you get 10 hours of free attorney time. And of course, we do these educational presentations by request, and we also, so prior to the 10 hours, what we will typically do is have you sign up for an educational consult. Devika and I do these. It's with our students and our professors. We come in and do a 45-minute consult and say, okay, what's your question, right? And then we can give you some information. We can't do legal advice in that context, but we can give you information which is going to help you then go to an attorney and use your time really efficiently, because by then you're going to understand, all right, yeah, what I need is, this agreement, or I need a patent application. In fact, I think a design patent application will be the one for me, because you've received that information, you know what to ask for, right? And you're going to have heard some of these terms and concepts so that when you go to work with an attorney, you can just hit the ground running. So, Abby, you put that in the chat. Yep, that's the link where you can go to apply for that.
And I have to say, I've used the services for establishing Cultivator and the process to get us nonprofit status, and it was absolutely amazing and just very helpful. So use it, and it's broad. It's any sort of legal question or process that your business is facing or going to face is available there. So it's really awesome.
Yep, we have a whole network of attorneys. So, depending on what you need, if it's intellectual property, that might come to me or to one of the other IP attorneys that participates in the program. But if it's, sort of general business, or even if it's a dispute of some kind, we don't do litigation through the program, but we will help with sort of early stage disputes. Those things are all fair game as well.
And I'm just going to emphasize again that it's free, those 10 hours of education, and then 10 hours with an attorney, which is it's unbelievable, really. So.
Yeah, I mean, that's thousands of dollars is normally that's going to be the bill for that for 10 hours. And, several thousand in some cases, depends on the attorney. So, yeah, it's really a valuable thing. And, I think the attorneys seem to like it too, because, they get to help people who really do need the help and get some small businesses off the ground and running. At least for me, I mean, because I do, in addition to teaching at the school, I do some of these, I'm in the network, and I think it's great. So, and I think other attorneys in the program would agree.
Great. Well, are there any other questions? And if anyone would like to take it off recording and ask questions, I'm happy to do that too. Otherwise, give it a second.
We got some time.
I just had a few comments. Can you all hear me? Or?
Yeah.
Yep.
Perfect.
Hi. I'm Dave Hurwitz. I'm a furniture maker. I'm based in Randolph, and I just want to thank you all for doing this presentation. I'm a designer maker, and I've had an issue with, I've consulted with Lawyers for the Arts many years ago, who always said, put a Circle C on all your designs, and but I have a pretty good understanding of the limitations of copywriting unique designs. But I'm at the point where I have one particular design. I call it a taffy mirror. It's a carved wall mirror that I've been making for 25 years. And in the time I've put them online, they're just people knocking them off left and right now. And they're some being made overseas. But what I'm finding now is they're selling them on Etsy. And I know the process. I can go to Etsy and try to get them taken down, but it's kind of like whack-a-mole, it's sort of this endless battle. And I'm kind of at a point where I think I probably need to register my designs and then maybe go after the bigger company, Etsy, about potential lost sales that I'm experiencing. So I really appreciate all this, and I would like to do a follow-up consult with this 10-hour thing, because it's like my cases, I know it's kind of a unique thing, but I'd definitely be curious about what the best paths would be to try to get anywhere with it. If possible.
It's not as, thanks for that comment. I mean, it's actually not as unique as you think. I mean, this is exactly the kind of thing that happens where, you get, it's always the best, most valuable design of the company, right? It's the one that's going to get big traction in the marketplace.
Right.
And it gets knocked off. And yeah, I mean, a copyright registration can definitely help with that. Even unregistered copyrights can be enforced. They have to be registered before any kind of lawsuit can be brought.
Yeah.
But copyrights do not have to be registered to put a letter on letterhead from an attorney that says, "Hey, copier, you're in trouble, knock it off."
Right.
Right. So that can be done. Yeah, I mean, the Etsy piece is kind of interesting, right? Because there's going to be a question about whether they are responsible and what the terms are and so forth. But that's exactly the kind of stuff that you could dig into with an attorney and try to figure out where you stand and what your best options would be for enforcement.
Yeah. Okay. Yeah, because the other thing too is like I have a pretty long track record with Etsy. I've been selling with them since like 2013, so I have all the record of everything that I've ever posted and sold on that site. So I'm hoping that maybe that can help bolster my case, but I guess that's needs to be seen.
I mean, there's always, there's the copiers themselves too. Of course, they are liable, right, for copying. And so, or might be, right, depending, it's all circumstances like we talked about. But, it can be the case sometimes where it's enough to go after a few of the high profile copiers. And the other copiers take notice and say, "Oh, yeah, this one's not worth it anymore to me."
Right.
Because I'm going to have to defend, I'm going to have to hire a lawyer. I'm going to get this letter. I might get sued, and then I have to go to court. And they're just like, "Nah, never mind. I don't want that hassle." Right. This is a big part of what registration, I think we didn't really talk about this, but I think one of the useful things of registering IP, whether it's copyrights, trademarks, or obtaining patents, there is a deterrent effect, or there at least can be, right? Where people are going to look at that, would-be copiers are going to say, well, yeah, never mind, actually, because I could make some money doing that, but I might lose it all and more when they come after me because I see that they're registered, right? Many copiers are not going to be that sophisticated, but a lot of the big ones are. The big companies, for example, who might see a design and be like, "Yeah, we can make money making that." They're going to do due diligence. They're going to find out if there's IP around a design they want to copy, and if there is, probably not going to do it. It's not worth it. So that's a factor to having IP as well. Great. Oh, Carolyn asks, do inventors need a complete prototype before filing a patent? So no, the answer is no. It does not have to have been made. So this goes back to the requirements. We talked about novelty and non-obviousness and eligibility, certain things, living beings and so forth. There's another requirement that the patent application has to enable a person of ordinary skill in the art to make and use the invention. So if you can meet that standard, enablement of a person having ordinary skill in whatever your art is to make and use the invention, then you have done what you need to do in terms of describing the invention in your patent application. So if the thing is sufficiently complete, if you can give a description that's sufficiently powerful so that someone could go off and make it, right? Then that's enough, and you don't have to make it yourself, right? A really good set of drawings, a good design, that's enough. Doesn't actually have to be, brought into the physical world before filing.
Okay, well, there will be a recording. I think you'll get the link after everything closes down, but I'm also going to have a YouTube channel where this will live on Cultivator's website. Thank you, Brian and Devika, for coming and presenting today. This has been really great. And thank you for attendees. Enjoy your evening and have a good one. Thanks.
Thanks, everybody.
Thank you all.
Bye.